I want to welcome to the program this afternoon the Attorney General for the great state of South Dakota. I have my South Dakota mug right here, as a matter of fact. Marty Jackley is with us. Mr. General, thank you, sir, for your time.
You bet, Cam. Appreciate the opportunity.
Absolutely. Well, listen, I'm glad we got a chance to talk with you. Let me ask you, why did you decide to sign on to this Amicus brief, to be a part of this Amicus brief that is taking issue with the New York SAFE Act? You're the Attorney General of South Dakota.
Certainly, and of course, and I believe very strongly in this, one of the major responsibilities of an Attorney General is to protect both our state and individual rights, including our constitutional rights. Hunting here in South Dakota with semi-automatic firearms for pheasants, waterfowl, and big game is really commonplace. And I felt in looking what had happened in the ban, a categorical ban on semi-automatic weapons really infringes upon the core of the Second Amendment. And even though it just applies in New York, that Second Amendment applies across the nation. And I was concerned that further interpretation by our federal courts allowing for this type of limitation or infringement was not good for South Dakota. So I very happily joined with 21 of my colleagues, both Republican and Democrat attorneys general, really defending the Second Amendment rights of our citizens.
So what exactly is the argument that you and your fellow attorneys general are taking in this friend of the court brief?
It's really premised upon the Second Amendment, the belief that when it comes to hunting, self-defense, target practice, the right to own arms for those purposes, that a court has to apply the highest scrutiny in protecting the Second Amendment rights. And in looking at the actual ban itself, coupled with the New York District Court decision upholding the ban, we felt strongly that the proper standard of the highest scrutiny in support of the Second Amendment was not applied, and it's a straightforward Second Amendment argument that this type of a categorical ban clearly infringes upon the rights as laid out in the Second Amendment.
Okay. Were you pleased by the number of other attorneys general around the country who signed on to this? I mean, it's nearly half of the folks that hold that office, that position in the United States.
You know, certainly I was pleased that both Republican and Democrat attorneys general felt strong enough to put their name and their state behind a brief that really seeks to defend and protect the Second Amendment. Certainly I had hoped that it would be a higher number, but at 21 you're approaching half of the state attorneys general. And I understand that some attorneys general may be waiting also, that right now this brief is filed in the Second Circuit Appellate Court. Many attorney generals have just a policy that they won't weigh in until it becomes United States Supreme Court. The reason I weighed in early is I think this is an important issue and hope that we can really overturn that district court's decision limiting the Second Amendment. So what I'm saying is I think you'll see even more attorney generals joining should this issue go further.
Okay. I certainly hope so. But again, I'm glad that your office and others are getting involved at this early date. As you say, this is a hugely important issue here. The Supreme Court has, in Heller and McDonald, recognized our right to keep and bear arms. They've recognized that it's a fundamental right, but what that actually means now in everyday life for gun owners and for Americans who want to exercise that right is still very much an open-ended question. And as you say, let me ask you this, Mr. Attorney General. What do you think the response would be from South Dakotans if all of a sudden they were told that the guns that they own were all of a sudden banned, were deemed to be a violation of their constitutional right to keep and bear arms?
You know, certainly I don't believe that would go over well. As I mentioned earlier, I mean, we all enjoy here in South Dakota the ability to hunt pheasants, hunt waterfowl, hunt big game with semi-automatic weapons. You know, my wife, I grew up using an old 870 pump shotgun for pheasants and waterfowl, and my wife bought me a semi-automatic Benelli, which is strictly used for hunting. And I think, like many South Dakotans, wouldn't be willing to give up that right, that basic right, without certainly a very strong court battle. And so, and I think too that that if our legislature here in South Dakota or the federal government were to put in place that type of a ban limiting Second Amendment rights here in South Dakota, that there would be both election consequences as well as court challenges.
All right. Well, listen, again, I really appreciate you joining us on the program. And I hope that we can talk to you again as this case moves forward, because I have a feeling that, while it's at the appellate court level right now, at some point the Supreme Court's going to be considering this case.
Certainly, I think a lot of credit needs to go to the Alabama Attorney General's office. That was really the driving force behind the briefing. And certainly the NRA. I mean, several of us, like myself, I'm an NRA member, appreciate the assistance the NRA gives us. When they reach out to us and point out the importance of these issues, those things are all helpful as we attorney generals review what we need to do to be protecting Second Amendment and other rights for our citizens.
Absolutely. Attorney General Marty Jackley, thank you so much, sir, for coming on the program. Hope we can do it again soon.
Thank you. Have a great day.